talk about cost, we know that it is something that we need to pay to the other people or the other people need to pay to us. But however, is it the same as the court order for cost? That is the purpose of discussion today, which make you more understand about court order for cost. Now, before we discuss more deeper on this issue, we must first take a look at the Order 23 Rule 1 of Rules of Court 2012. Well, it stated that when the defendant at the matter time is of view that the plaintiff, when he lost, he will not pay the cost to the defendant can actually apply for security for such cost to the plaintiff, and the court may grant the security of cost if he thinks it is just for the defendant. So, the order basically explained that if you think that your opponent now, after lost the case, that they don't want to pay, you may plead for a guarantee or security to the court about the cost to ensure your opponent will pay you after the case. Well, that sounds relevant and it is just to you, right? However, this rule actually had been raised in the case of Crozat against Broadgen in the year of 1984, where the decision given by a poor Colin G in this case had become a crucial dictum. Well, the judge in this case held that a major matter for consideration is the likelihood of the plaintiff succeeding. If there is a strong prima facie presumption that the defendant will fail in his defense to the action, the court may refuse him any security for cost. Court may grant, court may refuse. Oh, so based on the decision just now, we can understand that when it comes to the issue of cost given by the court, it is actually not a right to the parties anymore, but it is based totally on the discretion of the court. Now, before we go more deeper on the discussion about the issue today, let's understand more about the nature of the court order for cost itself first. Now, firstly, court order for cost is being mentioned under Order 59 of ROC 2012. Court costs are what the court usually awards you when you have succeeded with your claim or your defense to your case. Court costs are supposed to reimburse you back for expenses incurred when you are having your claim or defend your case in the court. The idea is that since you were successful in your claim or your defense and incurred some expenses in doing so, the losing party should pay those expenses. It is not for every expenses incurred related to the claim of defense, but it is just court-related matters only. For example, let's do some calculation here. If you somehow had expend, let's say, about around 10,000 ringgit only for your case, the court order for cost cannot amount to 10,000 ringgit. But perhaps the court can order for 5,000 ringgit as to the cost for your case, because the court need to look into the matter that is related with the court only, but not totally. The court can cover the total expense of your case. So that is the nature of the court order for cost. Now, if you ever have a case at the court and somehow you heard that the judge in his judgment has stated in the court clearly that you had been awarded with the cost there is very important, because you need to tell to the staff, or you need to alert with the staff of the court that your case had been awarded with cost. For example, the staff will ask how many costs for your case. The judge had given you the cost of 5,000 ringgit, for example. So now the staff can know that it is must the plaintiff to pay you with 5,000 ringgit. Now, if we refer to the table that being mentioned under Order 59 Rule 1 of Rule 1.3 of Rules of Court 2012, it has been mentioned there a few terms that are related with the cost or related with the court order for cost, which we can say that there are a few there to make we more understand about what is exactly or what is the type of cost that are being given or being awarded by the court. For example, there is a term of cost reserve, cost in any event, cost here and below, and also cost paid forthwith. So all of these terms are important for the court to differentiate between type of cost that being awarded to you. I believe that in order to make us more understand about the nature of the court order for cost, we must see into the decided cases that are related with this rule. So in today's discussion, I want to highlight one case that is related with this rule, which is Hong Leong Bank Berhad against Lee Carlson, where the judge in this case had mentioned that the object of awarding costs to the litigant is to indemnify him for the expenses he had incurred in successfully establishing his legal rights. The discretion of the court is very wide, but has to be exercised judicially and on established principle. So now, based on this case, we can understand that the court is awarding the cost to the parties because he had successfully establishing his right in law. So the discretion of the court make the court can award the cost to the parties. Well, now, as mentioned above, court order for cost is somehow related with the discretion of the court. Well, briefly, it actually being mentioned in Order 59 Rule 2 of Rules of Court 2012, which stated that it is the discretion of the court to award the cost for the parties that plea before court. Yeah, well, in order to understand more about the discretion of the court that is related with the awarding of the cost, I shall bring another part of this video. So, let's go. In conclusion, not all of the cases have the costs that being awarded by the court. However, in order to safeguard the interest of justice of the public, the court may award the cost based on the ruling or the order that being discussed today. There are certain circumstances that might influence the judge to award the cost in such case. For example, the complexity of the case or the length of the case. However, it is not something that confirms the judge to award the cost because, as being mentioned in the dictum by Per Colin J, it is totally based on the discretion of the judge. Based on the discretion of the judge whether to award or to give the what's so called as court order for cost or not to defendant. If somehow there is a probability to see that the plaintiff is going to lose the case, so the defendant should get the cost. However, if somehow plaintiff is succeeding, the defendant should not get the cost. It is something that is based on the discretion of the court. So since you had understand about the cost or the court order for the cost, and also how the court discretion affected the decision for the cost, you now can actually plea for the court for the cost if somehow it is must for your case. With that, I will thank you to everyone for watching this video. I'll see you next time.